Hello, and thank you for watching Minutes on the Matter with Dickinson Wright. I'm Cynthia Leal, and today I'm pleased to introduce Caleb Green. Caleb Green is an associate in the Dickinson Wright Las Vegas office. Today, Caleb will talk to us about IP considerations for landlords during the eviction process. Caleb recently published an article to our firm's website entitled Nevada Landlords Beware, Avoiding Intellectual Property Liability During the Eviction Process. Caleb, can you tell us a bit about this article?
Of course.
Yeah.
So as you know, due to the COVID-19 pandemic, many states have enacted various eviction laws which prohibit landlords from proceeding with the eviction process. So in writing this article, I discuss a 2019 case out of the Seventh Circuit, which appears to involve just a tenant-landlord dispute, but evolves into IP litigation. Specifically, in the Narkowitz Lane v. Doyle case, this case arose in 2004 when the tenant, who's also an artist, leased out a storage space from the defendants, the Doyle family. And all was going to plan until the tenant became delinquent. So like any reasonable landlord, the Doyles began the eviction process, but they made one big mistake in throwing away over 1,000 of the tenant's artworks that were in the storage locker. So the tenant subsequently went to federal court, brought a claim under the Visual Rights Artists Act, and ultimately came away with a $300,000 judgment.
And you mentioned the Visual Rights Artists Act. Could you explain to us what that is?
Sure. So the Visual Rights Artists Act is an amendment to the Copyright Act, and it essentially gives artists the power to prevent others from modifying or in some cases destroying their protected artworks. So like we saw play out in the Doyle case, when someone destroys these protected artworks, it may entitle the artist to compensation.
And how is the Doyle case relevant to the expiration of COVID-19 related moratoriums throughout the United States?
It is extremely relevant because as these evictions moratoriums are lifted and the eviction process will resume, landlords and property owners really need to take care of tenant property, especially items such as paintings, photographs, and other similar protected works, because by damaging those, as we saw in the Doyle case, or destroying them, they may open you up and expose those landlords to IP exposure and liability. Also, they may want to also consult with attorneys who can include certain waiver clauses in your lease agreements as an added layer of protection.
Well, thank you for your time and knowledge on IP considerations for landlords, Caleb. That concludes our today's segment of Minutes on the Matter with Dickinson Wright.
Thanks, Cynthia.
If you have any questions, here's Caleb's contact information. For additional information, check out our website, dickinsonwright.com.